and I would be inclined to agree with you on that. We simply don't know at the moment, following the line in case law. We need another case to get up through the system, at least to the Court of Appeal, to discuss Moncrief and Jameson and Birdie and Channer in order to determine whether one can exist. But quite an interesting topic. Okay, insolvency now, and in particular transactions at an undervalue. Here, under sections 238 339 of the Insolvency Act, a transaction can be set aside after 2 years by a creditor for a company and 5 years for an individual. However, where that transaction is intended to defraud creditors, there is no statutory time bar, so there is no limit on the period whereby a creditor can bring a claim to get it set aside. Now, this is evidenced in Sands and Clitheroe, rather unfortunate case. Mr. Clitheroe here was a partner in a successful firm, and for no other reason other than he was cautious, he gifted his share of the matrimonial home to his wife. Everything was fine until 15 years later, and he was unfortunately declared bankrupt. Now, in this case, the court held that section 423 did apply. That transaction was intended to defraud creditors, because it was putting it away from himself, despite the fact that that transaction had occurred 15 years ago, and all his creditors now were new, so he didn't have any of them at the time of that transaction, and that he wasn't involved in risky business, which seemed to be the test that the courts were applying up until that point. The court here said that that was just one